Hello and welcome to our DMH Employment Law podcast. We are going to be discussing interim relief applications today, and in particular, the staggering increase in interim relief applications that many of us are now seeing. We will focus on those interim relief applications relating to protected disclosures, but there can be interim relief applications for other things, including where somebody is dismissed for a trade union reason, membership or activity. But as most of the increases relate to protected disclosure dismissals, that's where we will focus. I'm delighted to be joined by Lydia Goodman today, solicitor with me, Rebecca Thornley-Gibson in the employment team at DMH. And I'm going to start off by just explaining what interim relief is, because it's been relatively rare up to recently. We're all going to have to upskill ourselves on what interim relief is and how we deal with it when we receive the inevitable application. What I'm going to do first, though, is just set out what interim relief is, because I think that is that's important, as many of us will probably not have dealt with that many interim relief applications. So, interim relief is an emergency remedy which will be available to claimants where they have been dismissed in certain automatic unfair dismissal scenarios. The most common are where they have said that they were dismissed for a reason or principal reason relating to whistleblowing, or where they have been dismissed where the reason or principal reason related to trade union membership or activity. As I said, we'll look at the whistleblowing aspects. Now, interim relief has to be applied for very quickly, within 7 days from the termination date. So claimants need to move quickly with this, and the tribunal will then move to have a hearing as soon as practicable after that application. Now, that is putting a lot of resource pressure on already stretched tribunals, but they are moving quickly with listing interim relief hearings. So what we're seeing is a very heavy burden on the respondent to prepare for that interim relief hearing. Now, the interim relief tests are quite high. They put a very high burden on the claimant to show that interim relief should be granted. And effectively, a tribunal will have to determine that an individual had a pretty good chance of succeeding at the final hearing on their claims. So that isn't just it's more likely than not that they'll succeed, it's a pretty good chance. A lot more than 50%, a lot more than reasonable merits of success. So the burden is on the claimant. However, if the claimant does succeed with their interim relief application, the remedies are onerous. So the tribunal can order that they are reinstated in their role until the final hearing, or that they are re-engaged in another job with similar terms and conditions, or if those two remedies are not possible or the respondent refuses that, then the tribunal can order the continuation of the claimant's contract until the final hearing, with the significant issue that they continue to be paid. So if we're looking at current tribunal timescales where it could take you 12, 18 months, 2 years to get to a final hearing, if a claimant succeeds in their interim relief application, they are going to have a good financial cushion until that final hearing, which is probably one of the reasons why there is a significant rise in claims. And with that, I'm going to pass over to Lydia, who can talk through some of the issues regarding those increases in claims.
So interim relief is something that has crossed my desk before, but as Rebecca was saying, it's rare. But in the last, I suppose, month or so, it's just significantly increased. And what we're seeing more and more is applications that appear to be generated by AI. And there's a ChatGPT sort of layout that I think we're all becoming increasingly familiar with. And that's what we're seeing a lot of. And as Rebecca was saying, these are obviously incredibly onerous for the employer to respond to. There's a very quick time frame in which employers do have to respond, and there's a lot of legwork in terms of collating all of the relevant evidence. And something that we've certainly been doing is preparing witness statements, because actually that's a really helpful way of presenting the evidence to the judge. Now, obviously, that's a huge burden for the employer to turn around in what can often be a week before they're notified of the interim relief hearing and when the hearing's actually listed. And it's obviously quite a big burden for the tribunals as well. Rebecca and I aren't seeing listings until sort of 2028, 2029. I saw one listing for 2030. So there's already a sort of big push on the tribunals to get things listed, and they have to get interim relief applications listed so quickly. So there's a huge burden, and it's very clear that the tribunals have been seeing this increase because they've issued some presidential guidance. So the president of the Employment Tribunals has issued some guidance on applications for interim relief. And I think there are three really interesting takeaways from the guidance I'd like to talk about. I think, firstly, the guidance sets out a nice introduction to interim relief claims, sort of briefly sets out the law, but it does explicitly say that most applications therefore do not succeed at paragraph 3. And at paragraph 4, it then goes on to talk about the significant increase in applications, largely in protected disclosure cases, and that's why Rebecca and I have chosen to focus on that. And the guidance itself actually indicates that a lot of these applications have sort of had AI involvement. And then the president of the tribunal in this guidance actually goes on to say that the tribunals used to receive about 20 applications a year, and they're now receiving a similar number each month. So I think we can expect to see a lot more interim relief applications in the coming months. So it's one that employers are going to need to be really hot on. The second really interesting thing I think about the guidance is all to do with the material. So I've just been saying that actually it's really helpful to prepare a witness statement. The presidential guidance and indeed the tribunal rules say that the tribunal must not hear oral evidence unless it directs otherwise. However, I think just having someone in an organisation to provide a witness statement, just to speak and take the judge to the documents and kind of put everything into perspective is incredibly helpful in terms of persuading a judge. And obviously the sanctions in the event that interim relief are granted are so onerous that it's worth sort of doing that legwork initially. And I think lastly, what I find particularly interesting is that at paragraph 29 of the presidential guidance, it actually goes on to talk about the difficulties of using AI, and it expressly says litigants who use AI to assist them have a responsibility to ensure that what is submitted is concise, relevant, and accurate. And I think that's some really interesting phrasing, and I think we can expect to see a lot more of that. However, the onus obviously then falls on the employer, who often has to deal with these lengthy applications. And actually, increasingly, litigants in person that don't necessarily entirely understand what they're presenting to the tribunal. And I think that's one of the biggest difficulties. So, Rebecca, what do you think is one of the biggest difficulties for employers, and how do you think they can mitigate that?
Well, employers can't avoid having an interim relief application land on their desks. So they can't avoid that completely. As you said, with the AI increase, a claimant tapping away and saying, I've got a whistleblowing claim, what can I do? Is probably going to get a nice nicely formulated answer of, well, put your tribunal claim in, and also you could get paid until the final hearing if you make an interim relief application. So that's not going to go away because that's on the increase, the knowledge that claimants will have from AI. But I think in order to mitigate risks, one of the key things for employers is to ensure that the reasons for dismissal are clear in the dismissal outcome letter. And that's where, regardless of how long the individual has been with the organisation, the dismissal outcome letter is so important for tribunals. And that is what they will focus on, particularly in interim relief applications, where they're having to determine, is this the principal reason? Is the whistleblowing the principal reason for dismissal? So if the dismissal outcome letter talks about conduct, talks about performance issues, and is backed up with evidence, which may then have to go into that interim relief application bundle, the respondent has got a much better chance of defeating the application. If it's just a one-liner, which is, you're dismissed with effect from today, and that one-liner has been scripted in that way because the employer thinks this person's still in their probation or this person doesn't have 2 years service, obviously all to change in January next year. But if they've just done a one-liner because they think their risk is low or almost zero, I think the days of being able to do that one-liner dismissal outcome letter have gone. And to mitigate, all sorts of risks and interim relief risks, there needs to be more care taken over the dismissal outcome letter. I think there also has to be more care taken over pre-dismissal considerations. So again, if you've got the performance and the conduct, don't wait necessarily until the dismissal meeting to articulate that. Have an evidence trail clearly showing that there have been concerns, and hopefully, those concerns have been raised with the claimant prior to the dismissal meeting. And then I think the third one is, if there are whistleblowing complaints, which are not always badged very neatly as this is a whistleblowing complaint, sometimes you have to work out that it's a whistleblowing complaint. But if there are such whistleblowing complaints, deal with them properly, deal with them in accordance with your whistleblowing policy, and make sure that if there is a protected disclosure, you are dealing with that properly and the individuals know how to deal with that. I think maximising chances of successfully defeating interim relief applications. I think, talking about the guidance Lydia referred to, send that to the claimant at an early stage, make them aware that this is going to be quite difficult for them to get over the hurdles of being able to show that they've got a pretty good chance of success, at final hearing that the employment judge can determine at that interim relief hearing. I would also say, sounds very flippant, as the respondent turn up to the hearing. Although the burden of proof might be on the claimant, if you don't turn up to the hearing, then what a tribunal can do is they can order the continuation of the contract until the final hearing, which means you are going to be stuck with paying that employee right up until the final hearing. And they don't have to do any work for that. They can sit at home and you just have to pay them until the final hearing. And again, as Lydia quite rightly identified, preparation for the hearing is key. The witness statement is key. Identifying documents justifying the dismissal is key. Really focus on those reasons for dismissal. And I think my last point is, if you have a really badly pleaded claimant's claim, again, perhaps it might come across as a little flippant, but don't necessarily ask for any further and better particulars of that claim prior to your interim relief application, because a badly pleaded claim and deficient pleadings are going to be the claimant's enemy. And a badly pleaded claim is not going to win an interim relief hearing. So don't try and get more details from the claimant prior to your interim relief hearing itself. So those are my tips in a relatively limited time we've got for this podcast. Do you have any takeaways, Lydia, from your experience so far of the interim relief application increases?
Yeah, I think there are two key takeaways actually for employers. And you mentioned, Rebecca, about drafting that dismissal letter. And you also touched upon where an employee is dismissed for reasons of conduct. And quite often, particularly in protected disclosure cases, it's increasingly common, I think, that a claimant or an employee will make protected disclosures in a way that amounts to misconduct or gross misconduct. And the employer then has the sort of extra hurdle to jump over, I suppose, in separating the making of that protected disclosure from the conduct. And I think it's really important for employers to instead just focus on the conduct, focus on the way in which that protected disclosure was made, and just steer very clear of the protected disclosure itself when they're responding. And I think the second key takeaway, Rebecca mentioned sending the presidential guidance to a claimant in proceedings. And I think that's a really good idea, particularly as at the end of the presidential guidance, there's a subheading called Practical Observations, and it effectively sets out that the claimant has to have a pretty good chance of showing that one of their protected disclosures effectively related to their dismissal and was the reason for the dismissal. And it kind of sets out the law and the kind of practicalities that claimants do face. So providing that the claimant actually reads the guidance, I think that's actually a really helpful steer for both claimants and respondents in interim relief proceedings.
Thanks, Lydia. I think my key takeaway is as soon as that application lands on your desk, then get moving, because you might only have 7 days notice of that hearing. And as Lydia and I have experienced, you are effectively almost preparing for the final hearing to some extent in a 7-day period. Although the tribunals tell us to be proportionate about the documents to submit, it is still a weighty exercise. So do not sit on that application. Either get on with it yourselves or certainly, instruct solicitors very early on. So with that note, thank you for listening. Please follow us on LinkedIn, where our podcasts will be uploaded. But obviously, if you use your usual podcast channels and Podbean, Spotify and Apple, you will find us on there. And thank you and goodbye.